Hi, everyone. Thank you for joining us at this panel on competition claims. I'm Loree Kovach. I'm the Senior Vice President at Epiq. We're a global legal services company. The division I work for specializes in class action settlement administration. We operate in the US, in Canada, here in the UK, as well as in the EU. I've been doing settlement administration for about 20 years, so lived through quite a bit of it. We have a great panel here today. We've got practitioners from Canada, from the UK, and from the US. I'm going to hand it over to the panelists to introduce themselves. David, do you want to start?
Hi, David Scott, founding member, partner of Scott & Scott.
Hi, David Gadsden. I'm a disputes partner in the Toronto office of Baker McKenzie. Also the chair of Baker McKenzie's Canadian Class Action Group. Practice commercial litigation with an emphasis on class action defense. Great to see everyone, and thanks GLG for having me today.
I'm Ben Jasper, partner in Clifford in London. I'm one of the partners in our antitrust litigation team.
Great. So class actions in the competition space are evolving pretty rapidly, as everyone in this room knows. Today we've got unique perspectives from 3 different jurisdictions. So we're going to dive right in by letting our panelists give us some information on recent developments in each of their jurisdictions. Ben, want to start with you?
Sure. So I'm conscious there have been lots of previous panels which have touched on a range of issues. There have been real developments in certification before the CAT, which I know others have touched on. We've had the first rejections of applications to certify in REFA, case against Apple and Amazon. It's unusual because it rejected a proposed class representative, principally on the basis that following some quite challenging cross-examination at the hearing, there were concerns that she didn't sufficiently understand the funding arrangements and couldn't balance the competing interests. We've also had refusals in a claim relating to wastewater and water companies, but that's really a kind of technicality relating to our underlying sort of separate legislation. But there was also critically a refusal in the Roundtree case against the Performing Rights Society, which I think is really the first time that on the substance there's been a rejection and a concern about the theories of harm, the ultimate sort of proposed damages methodology. So really big developments in certification. Just last Friday, we had a really important limitation judgment. Limitation issues are a really significant battleground at an early stage in these UK CAT claims, where effectively the tribunal found in Gormson and Vodafone that claims couldn't be made on a standalone basis for the pre-October 2015 period. I think most opt-out collectives have already kind of got onto that there are only a few that really seek damages for that pre-2015 period, so I think that will be really interesting. Finally, we have also had liability judgments. We've spent almost 10 years waiting for liability judgments. It's been a mixed bag. At the beginning of the year in Le Paterel, we had the class rep failed to establish against BT an excessive and unfair pricing case. It was found to be excessive, but ultimately the fixed line charges were not found to be unfair. We've also had a rejection in Gutman and Southwest Trains, another abuse of dominance case. Some really interesting sort of comments by Mr. Justice Roth at the time, talking about competition law not being a general law of consumer protection, and companies in a dominant position not having an obligation to conduct their business so as to achieve the best outcome for consumers. So some really heavy-hitting sort of defendant victories, I think, at the earlier part of the year. But then just a couple of weeks ago, in Apple and Kent, we've had the first liability finding against Apple. We can go into the detail of that at some point, but I think my sense from claimant firms and from funders is that that is really seen as a bit of a shot in the arm for the regime. The first circumstances in which we've had a liability finding, although no final judgment as to the amount of damages. And I think that may encourage people to start bringing these claims again, because there has been a bit of a fall-off over the last year. So it's a bit of a whistle-stop tour, but there have been lots of really fascinating developments in the UK this year.
Yeah, thank you. In Canada, I think we have some regulatory changes that are pretty interesting as well.
That's very loud. I will circle back in a moment just on the class action. In the traditional sense, some developments there, but you're quite right, Loree. There have been some important developments in our regulatory regime. and specifically with respect to our federal legislation that governs competition law in Canada, the Competition Act. And really, these amendments have changed the landscape, we think, dramatically, including by opening up a new form of collective relief before the Competition Tribunal. So separate and apart from court systems, private parties in Canada have the ability to come before the Competition Tribunal and seek relief in respect of anti-competitive conduct. Traditionally, that's an avenue that just hasn't really been pursued much by private litigants, and there are a few reasons for that. Number one, the remedies available by the Competition Tribunal are relatively limited. Number two, none of those remedies up until recently included monetary relief. And number three, there's a fairly strict leave application test in place. But over the last couple of years, there have been a series of changes and amendments to the legislation, most recently in June of 2025, that are expected to lower the bar significantly and make the Competition Tribunal avenue a lot more appealing to private litigants. So I'll just talk a little bit about each of those. So number one, the scope of claims you can bring before the Competition Tribunal has been increased. Previously, private litigants could bring claims for things like refusal to deal, price maintenance, abuse of dominance, and a few other categories of anti-competitive conduct. Now that list has been broadened to include deceptive marketing, as well as anti-competitive commercial agreements. So the scope of relief and the scope of claims you can bring before the tribunal has increased, which is a meaningful development. That leave test that I referred to earlier has also been relaxed somewhat. So previously, a private party would have to convince the Competition Tribunal that the anti-competitive conduct that they're complaining about substantially and directly affected their entire business. Under the new amendments, that test has been relaxed. Now a private party only needs to demonstrate that the complained of conduct impacted their business substantially, either in whole or in part. So this is a meaningful change because a lot of private access applications for leave failed on this exact point previously. But now that private litigants only need to demonstrate that part of their business rather than their whole business has been impacted by the alleged anti-competitive conduct, clearly the bar has been lowered. The other thing that has been added to the leave test is a new branch relating to public interest. So now, for most claims brought before the Competition Tribunal, leave can be granted where it's in the public interest to do so. So this public interest test is novel. It's brand new to Canadian competition claims. Lots of commentary, lots of speculation about how that test will be applied by the Competition Tribunal. And there's already litigation before the tribunal, and parties are arguing about how that leave test should be applied, how the meaning of public interest should be interpreted. So there's a bit of a period of uncertainty. We don't have a decision on it yet, but we're in a bit of a state of flux until there's a body of case law developed. The other major amendment is that there are now new financial remedies as well as a new form of collective action available before the tribunal. So up until recently, there were no monetary awards available for private litigants appearing before the tribunal. That has now changed, and private parties can seek, if they get leave and if they win on the merits, they can seek a disclosure or a disgorgement remedy rather. And what's really interesting about that is that this disgorgement remedy can be distributed among the applicant as well as any other person similarly affected as the tribunal deems fit. And so in effect, there's been a new group action avenue created by these amendments. One note of interest from the bar in Canada is that despite this new change, there are not the established safeguards that we're accustomed to in our court systems in the traditional class action regime. Things like class certification, class-wide releases, court-approved settlements. So this new regime that's been brought into effect, it does not have those safeguards. So it'll be very interesting to see how how that plays out, how the Creative Plaintiffs Council and Creative Plaintiffs avail themselves of this new avenue for recovery, and then how the two systems interact with each other. And then just briefly back to class actions in the traditional sense, one overall trend I just wanted to point out, we seem to be seeing a bit of a pendulum shift in the certification of competition claims in Canada. Traditionally, plaintiffs have had a very successful track record of certifying competition claims. For years, the main battleground was really over damages methodology and whether or not the plaintiff's expert could advance a damages methodology that was credible, plausible, and showed that loss could be calculated on a class-wide basis. That argument, from the defendant's perspective, has really been run to ground now. We've got lots of appellate court, including Supreme Court, jurisdiction on the issue, and essentially there's been a fairly low bar set for the plaintiffs in terms of what they need to do to establish damages or the ability to calculate damages on a class-wide basis at certification. So defendants are now focusing on other areas of attack. They're arguing that plaintiffs' claims are speculative. They're arguing that they're not based in some basis of fact. And they're arguing that in many cases they're copycat class actions and that just don't translate into the Canadian legal landscape. So defendants are actually getting traction on some of these arguments, and we'll come to some of the cases as we continue the discussion. But for now, I just wanted to highlight what appears to be a tightening of the gatekeeping function of the courts at the certification stage in Canada.
Thanks. So hopefully this time next year we'll have some real substantive updates on those
I think
new
there'll be
regulations.
lots to talk about, yeah.
Yeah. David, you want to tell us what's going on in the U.S.?
Yeah. So I'm a claimants lawyer, and I think the approach that I'd like to take is, rather than share with you some of the decisions that have been rendered by the courts in the U.S., to give you some insight into what we as claimants/plaintiffs lawyers are looking at. And I'm going to do that because I think it's important for you to understand that as claimant lawyers in the US, and I also have offices in the UK, in Berlin and Amsterdam, there is a lot of cross-pollination between claimant lawyers and claims that are filed in the US, and they ultimately appear here in the UK or in Europe. So just kind of broadly speaking, when I look at trends within the competition space, I kind of look at two things. And I've been doing this about 35 years, so I have a data set in my head of how these things transpire. And I look at two things. In the first instance, I look at the financial pressure. And in the second thing, I look at the cycle. And when I speak of financial pressure, what I say is, I step back and I look and I say, we've had record inflation in the US, and we've had tariffs. We've had retailers who are now squeezing for margin. When you have that, that is a perfect confluence of issues where commodity-based products are going to be susceptible to anti-competitive conduct. So paper industry, electrical components, building supplies. When margins get squeezed, you see price fixing happening. Similarly, there is a cyclical nature to these cases. So generally it goes on a 10 to 15 year cycle. And you say to yourself, well, why a 10 to 15 year cycle? Because most of the time, old management is gone, and the new people in charge of the companies who are price fixing kind of have forgotten the punishment that they suffered as a result of fixing price. And so if you look historically, let's just take the paper industry, for example, they are recidivists, right? That industry is a recidivist for price fixing. And they're a recidivist, and it follows the same cycle, because you get new management, a certain number of years pass, and lo and behold, you have price fixing going on. So I know that in the US there's a lot of talk about sexy AI and ad tech and ad stack type of cases, but I would suggest to you all that you may see a real increase in commodity-style price-fixing cases. With that being said, there are some other areas that I think are very interesting from both a claimant's perspective and, of course, from a defense perspective. I think you're going to see AI in the AI generative space. You're going to see a lot of action. You're going to see cases where there are claims of exclusive dealing, tying, interoperability. I think also once the government finishes up its kind of current attack on big tech, you're going to see a lot of follow-on cases. Similarly, I think you're going to see a lot of action in the AI stack space. And for those of you who are kind of new to AI, the AI stack, there's hardware, there's data, there's the AI assistant. It all sits, there are chips. It all sits in the stack. And I think you're going to see a lot of action in the AI stack because you're going to have instances where people who are control within the stack or have various pieces of the stack are going to be able to give preferred treatment to certain vendors or friends, who are going to be able to pre-install certain software, who are going to be able to slow down competitors so they gain competitive advantage. So again, I think you're going to see exclusive dealing cases. I think you're going to see tying cases. I think you're going to see the type of cases where people get frozen out of the being able to participate within the stack. I also think that you're going to see kind of renewed interest in no-poach. And I share that with you because and when we talk about no-poach, what we're effectively talking about are competitors agreeing not to hire other competitors' employees. And although it has been chased to ground in kind of the most basic form, there have been numerous cases in the U.S. that have resulted in settlements of about 1.7 billion USD. There has been an increased regulatory scrutiny of these types of claims. So I think you're going to see that, but it's going to be a little bit different. In the first instance, I think there's going to be a lot of focus on franchise agreements and the terms of those franchise agreements, both in fast food, retail, and fitness, as to whether or not they contain provisions which are anti-competitive because they prevent poaching. More interestingly, and perhaps more appropriate given where we are now with AI, I think you're going to see a lot of focus on data-driven wage suppression cases. And in those cases, I'm sure you've all heard of AgriStats. AgriStats is a case where they provided granular detail in the poultry, pork, and turkey processing businesses as to wages, benefits, everything you could possibly imagine. It was shared among competitors. It was wholly viewed as anti-competitive. They've paid out about 400 USD in fines. I think you're going to see that in the wage space, wherever third-party data vendors are sharing granular wage data among competitors. You very well may see cases there. And then lastly, and the list is long that we're looking at, but I've just picked a few which I think are interesting. In the States, and this has less application here given the structure of your healthcare system, in the States, healthcare is starting to become on the fore of a lot of claimants and a lot of U.S. attorney generals. And that is because, the costs are so high. But I think you're going to see a lot of cases that address anti-steering with hospitals, where hospitals tell health plans, this is very U.S.-centric, of course, where they tell health plans, you must, if you want to use this hospital, you must take all of our hospitals, which therefore foreclose the health plan from its ability to go to a cheaper or a competitive or a more competitive hospital. That's one. And lastly, I think rebate walls, which occur within the drug business, where what happens is the drug manufacturers give such extraordinary rebates to the health plans that they are locked in and they cannot put other drugs on their list of approved drugs. I think you're going to see that. And then lastly, I think you're going to see a lot of what we call PBM, pharmacy benefit management litigation. But that is very, very US-centric. The others, I think, as I started, the others have application here because of the cross-pollination between claimant lawyers in the US and claimant lawyers in Europe.
Good question.
First of all, thank you for that list. I have a question on the AI tech stack.
Yeah.
Has there been any hint of litigation or potential litigation related to AI companies continuously investing in each other, creating a valuation bubble, because they're telling the market how important they are by buying each other's stock at ever-increasing value?
Yeah, and that's a great question. It's an interesting one. You know, it's much more of a potentially a securities style claim as opposed to a competition claim. Maybe there's a competition angle there, but if it gets pigeonholed into a securities claim, and it is one that is going to be litigated in the U.S., then you're suddenly going to be down the avenue of the PSLRA and all of the very, very strict pleading requirements associated with a securities claim. I think that what is fascinating about AI from our perspective is not only how quickly it is changing and how there is a lot, to your point, there's a lot, everybody is in bed with everybody else in one way or another. You're starting to see that. But what I find fascinating about it is, and it was just, I was just reading an article about the decision that came out with Meta and the FTC, is how AI is really changing the definition of product market in monopolization cases or abuse of dominance cases. And that, to me, is fascinating, but probably beyond the scope of this panel. But it's a really interesting issue because AI is now getting involved in commerce, e-commerce, and it is becoming an alternative platform to the Amazons of the world or the Walmarts of the world. And therefore, the definition of the product and the product market has changed. You know, the geographic market and the product market has changed. And I think it's going to be really difficult in some instances to maintain an abuse of dominance case when you have AI coming in and moving so quickly. So, but your question is a good one. I guess I don't know. I haven't seen it. We've been I've thought about it. It's not different from the case that was recently filed in the coal business by certain Republican attorney generals against the investment companies who own the coal companies and have claimed that the BlackRocks of the world have been influencing and colluding on coal and coal pricing and coal output. So something similar to that, kind of a novel approach. Yeah.
A lot of interesting stuff coming up.
Yeah.
So a couple of the panelists have touched on this, but we wanted to talk about copycat claims. So we're seeing very similar claims in multiple jurisdictions. I know we as an administrator often see the same settlement in multiple countries, and so we wanted to get some input from the panelists on that. Want to start, David?
Yeah, sure. So copycat claims are quite common in Canada. It's not an uncommon strategy for Canadian plaintiff-side class action lawyers to carefully monitor what's happening in the U.S. And then with a view to filing similar claims in Canada. So in the competition world, you know, typically the pattern is there'll be a Department of Justice investigation or another regulatory investigation or proceeding in the U.S., often resulting in some form of guilty plea. U.S. class actions will then pop up, and then shortly afterwards, Canadian class actions will pop up. Often those Canadian class actions look very similar to what's been pleaded in the U.S., and there's a reason for that, and the main reason is that often plaintiffs' counsel in Canada, really all they have to go on is what's in the public record. So at least at the outset of litigation, it's not uncommon to find Canadian pleadings essentially mirroring what's been pleaded in the U.S. And I'll just pause to say that the concept of copycat class actions is not necessarily in and of itself problematic. I think there are certain cases where it might make sense for Canadian plaintiffs' lawyers to pursue a Canadian iteration of U.S. class actions. That said, increasingly courts are applying more scrutiny to Canadian class actions that are based on U.S. litigation. So I wanted to talk about a couple of examples. One is the tuna price fixing case. And in that case, the Canadian litigation followed antitrust proceedings in the U.S., which found that certain manufacturers and producers of tuna conspired to fix prices in the U.S. market. So the Canadian plaintiffs pleaded that essentially the same conspiracy extended to or was directed into Canada. That case was not certified, and then at the Court of Appeal, the Ontario Court of Appeal upheld the motion court's decision not to certify. And I just wanted to read you a couple of brief quotes from that Court of Appeal decision. So the Court of Appeal found that the plaintiff's claim wrongly assumed that a proven price-fixing conspiracy involving the sale of tuna in the United States could simply be extended to Canada, even though the Canadian and U.S. markets for tuna were entirely separate. And the Court of Appeal also noted that the fundamental problem was that the evidence relied on by the plaintiff had nothing to do with Canada and concerned conduct that occurred only with respect to the U.S., which had an entirely separate market for tuna. So a pretty critical rejection of the plaintiff's case in the tuna price-fixing litigation. And then the second case involves alleged price fixing with respect to hard disk drive components. And we are currently defending a Japanese-based manufacturer in this case, which was brought in British Columbia. Like the tuna case, the Canadian litigation followed U.S. DOJ investigation and U.S. class actions. But the unique thing about this case is that there's very little connection to Canada. And what I mean by that is the defendants, all defendants are based overseas in Asia. None had a physical presence in Canada. There are no contracts formed in Canada, no direct sales into Canada, so there's no direct purchaser claim. The alleged conspiracy was not alleged to have taken place or been formed in Canada. So really the only connection to Canada is the fact that these computer components made their way into the Canadian commerce as part of a subcomponent of a larger end product, mostly computers. And so we challenged the jurisdiction of the British Columbia courts, arguing among other things that given that what we said was a very tenuous connection, if the courts accepted jurisdiction, it would be setting essentially a new low watermark for jurisdiction cases in Canada, and specifically in the competition and price fixing line of cases. The motion judge did not accept that argument, so the case was certified. The courts assumed jurisdiction. The British Columbia Court of Appeal upheld that motion decision, and we filed leave to appeal the decision to the Supreme Court in the fall of 2024. And just last week, we actually received word from the Supreme Court that leave was granted. So we'll be arguing that case next year. If it goes quickly, maybe I'll be able to report on it when I'm back next year. But obviously premature to sit here and speculate on what the outcome might be. But the simple point is that it's not a guarantee that cases that might be a good fit in the U.S. will automatically be a good fit in Canada. And we're seeing courts apply a little more scrutiny to claims that are based on litigation in the U.S. And from a defense perspective in Canada, that's a welcome development.
Yeah. Ben, what about in the UK?
Sure. So, I think I'd probably echo most of what David said, maybe just two additional observations. Often I think we find there are sort of regulatory investigations by the European Commission, by other enforcement authorities, and as night follows day, as soon as you have the sort of dawn raids of those in the US, you find yourself or your clients facing class actions in courts. I think what I think is very interesting is that you then, usually several years later, see very similar claims, or at least claims partly relying upon some of the sort of pleadings and some of the discovery to the extent that it's public, then being kind of re-exported into Europe and into the UK. I mean, a recent example of that is the sort of farmed Atlantic salmon case, begins with a European Commission raid. You've got class actions in Florida, you've got one in Canada, you've got DOJ investigation kicks off, and then several years later you've got retailer claims in the UK and much more recently a class action before the CAT. So there's certainly sort of cross-fertilization. I mean, I think that's pretty obvious. Maybe one point sort of against that is that there are obviously causes of action, in particular before the UK courts, which just aren't available in the US. And the huge growth that we've seen in the UK in the CAT collectives regime is principally standalone abuse of dominance cases. And at their core, many of those cases have unfair exploitative pricing at their heart. And as far as I'm aware, but David, correct me if I'm wrong, that is just not an abuse that is recognized as a US antitrust cause of action. So, and I think you even see that in cases, in the big tech sector, where you may have similar theories of harm in other aspects of the case being proceeded, in the US and within Europe more broadly. But in the UK, you've got this sort of additional unfair pricing element, which, I think really is the trend, even though it ultimately started in quite an obscure pharmaceutical sector type regulatory enforcement environment in the UK. It has now morphed into kind of practically every consumer product app store type claim that you can imagine.
Yeah, and I think you see that in some of the litigation against MasterCard, for instance, right? In the US, we have the Visa MasterCard interchange case, $6 billion settlement involving merchants. But here you have Merrick's, it's looking at how that was passed on to the actual consumer. So it's an interesting sort of comparison. The other thing I think is interesting about copycat cases from the administrator's perspective is the possibility of class members being class members in multiple cases in multiple jurisdictions. A really good example of that is the foreign exchange rate price fixing case. So we handled that with David's firm in the US. There was a Canadian version of it filed, but because of slight differences in the class definition, you could be a class member in both, related to the same transactions. And so, that when you're recovering pennies on the dollar, there's not a lot of danger of over-recovery in that scenario, but it could be in cases with higher recovery, the possibility is out there for class members to receive back more than what they lost. And that's, I think, things that practitioners aren't thinking about when these copycat cases are coming out.
Right, so what are the interesting things about this idea of copycat cases? Because I would not use the term copycat case because there's it's a little bit pejorative, right? If you think about it from a claimant's perspective, if there is a case in the US that gets by the motion to dismiss and gets certified, it has effectively been vetted as a really good case. So from a strict business perspective, as somebody who is going to bring a case in an effort to seek redress, or you're going to pitch it to a funder, you've got the imprimatur of the US court saying this case has legs. Now, as David pointed out, there are hurdles because you have jurisdictional hurdles. There are certain problems you can encounter if you bring it into the wrong jurisdiction. But the idea that somehow, people are just taking case, the reason people want to take a case that has been vetted in the US is because US-style class action litigation is judge supervised to the most part, and the pleading standards are very difficult. So if you satisfy the pleading standards, and then if you satisfy the class certification standards, which is a trial in unto itself, then you are getting the thumbs up from somebody who says this case has merit. So it's much more likely that it will come over here or it'll go to Canada. Question?
What about the discovery aspects of the U.S. versus Europe? You see cases seeking litigation in the U.S. first just because of the liberal discovery rules.
You do, but you also have to appreciate that there is a mechanism for foreign action and foreign litigants to get U.S.-style discovery. It's called the 1782 action. And I'm sure most practitioners are familiar with it. When it allows you to file an action, if you have a case pending in Europe or in the UK, and you can make the argument that discovery will aid in the litigation of your case here, you can bring a 1782 application. You bring it in front of a judge signs off on it. If you get a 1782 thumbs up, then you are able to take discovery, US-style discovery. And for those of you who are unfamiliar with US-style discovery, it can be very intrusive. Think of your annual physical. It can be very intrusive because you are entitled to documents, you are entitled to sworn depositions that in the federal court are 8 hours per deponent. Some places allow you 20 depositions. You can get depositions they call them 30B6 depositions, record keeper depositions. Point being, you can have a tremendous amount of discovery. But that's available to foreign litigants, here as well, in Europe. And we see a lot of it. So that to your point about discovery.
So you mentioned funders. Do you all think competition claims are more or less attractive to funders in each of your jurisdictions?
I mean, they're hugely attractive in the UK, I think, or at least they have been over the last 5 or so years. I think there's been, I suspect a bit of a cooling off, partly because of the PACAR Supreme Court decision, although my sense is that most funding arrangements are shifting to a model where funders receive a multiple of their investment, so that's sort of been ridden to some degree. I think obviously there have been some quite high-profile losses that I touched on at the beginning of the year, but in the kind of, with the Kent and Apple development, I suspect that will be, that will provide some support to funders, particularly in those kind of app store type cases, those sorts of things that can rely upon similar theories of harm and causes of action. I think the other thing maybe to mention from a UK perspective is there's a government consultation which was published over the summer when everyone's on holiday, which is when they tend to do it. That seemed to have some pretty overt criticisms of the competition collective actions regime, even a line within the consultation from the government forward, which says litigation shouldn't be the primary means of a redress for consumers suffering harm in antitrust causes of action. So I think the sort of big unknown at the moment is whether the government is going to pare back the collective actions regime in the UK potentially. It's clearly received quite a lot of pressure from business and from other groups, and doesn't consider it to be sufficiently consistent with its growth strategy. So I think, it's a relatively buoyant market at the moment, albeit a maturing one. And I think the big unknown is whether the government is going to intervene to pull back slightly on the regime.
Yeah, so in Canada, I would say the short answer is yes. Funders are quite interested and willing to support competition claims. I think a lot of that has to do with the comment I made earlier about how traditionally and historically competition claims have been certified with good success track records for plaintiffs' counsel. That said, I think some of the I mentioned earlier, perhaps a slight pendulum shift in the other direction. I'm sure funders are paying very close attention to this and scrutinizing the cases perhaps that they're signing on for a little more than they may have previously. But yeah, in general, it seems to be an area of class actions that funders are happy to get behind.
Yeah, so I look at it in 3 buckets. In the U.S., as a class action lawyer who does contingent fee litigation, we self-fund. So there really is no need for a funder when we litigate in the U.S. But my firm also does a fair amount of corporate individual litigation in the competition space, both in Europe and in the US and around the world. In those instances, funders are very interested. So funders love a multinational that wants to bring a case, either a follow-on from an EU decision or a standalone case for a competition violation. They just love it. From our experience, in the collective regime in Europe, where you would have a funder, funders are hesitant about certain competition cases if they believe that the litigation is attacking the fundamental business practice of the company. And my experience has been they are hesitant in that instance because it takes a long time and they know the company is going to fight to the end. And therefore, it impacts their return on investment because their money out is much longer. So the analysis that I see in those instances, what I would call the third bucket, is what is the quantum, how much is potentially recoverable, what is the core cause of action, and how long is it going to take? And we have had cases where there's been big damages, big quantum, but the funders have been hesitant because they said, we project this to be a 10-year case. And it's very difficult to model your return on 10 years money out. So that's been our experience.
Yeah. So I'm cognizant of the time we have left. I wanted to give each of the panelists a couple moments to provide any closing remarks before we go to questions.
I think, I suppose maybe just touch on this government consultation again. There's this sort of concern, I think, in the consultation that the regime in the UK has been in place for 10 years, and yet we've seen very few liability judgments. Where there have been settlements, there have been concerns around the distribution of those settlements. So in one of the trains cases, I think the current sort of score on the doors is sort of less than 1% of the class coming forward. So there's been, I think, a real sort of criticism of the regime. Even though I'm a sort of defense side lawyer, I think that criticism is pretty unfair. We had a period of 5 years where the regime was locked up in a battle that went all the way to the Supreme Court on certification. We've had, almost every interlocutory dispute you can imagine in the regime, over the course of the last 10 years. And, in the past year, we are now seeing liability judgments. We're seeing greater numbers of settlements. I think we're seeing a sort of maturing regime where the CAT is exercising a greater level of scrutiny at certification too, although sadly not the same level of scrutiny that the courts in the US exercise. So I think, even though I'm on the sort of defense side, this regime is maturing. I think funders are becoming more sophisticated in understanding where the real risks are. And so I think really the government's calls to sort of constrain this regime, or what appear to be calls to constrain it, are premature. I think we need a bit more time to see it mature.
Yeah, and agree with you that it really seems like it's getting momentum now. So, David?
Yeah, I think, so one of the reasons that I love practicing in this area is that, there are always new developments, there are always cutting edge arguments, there are always new cases being creatively pursued and new defenses that need to be applied to deal with those cases. So I guess my comment is simply that Canada's in an interesting place right now, and that they are in a state of flux with these new Competition Act amendments. So it'll be very interesting to see how that unfolds, whether it will actually impact a plaintiff's decision on how to seek relief, whether they'll continue to go to the courts or they'll take up this new avenue that's been made available for the private litigants in the competition tribunal. So lots to talk about, lots to watch and stay tuned on. And like I said, hopefully this time next year I'll be able to update the group on all of these things as they unfold.
Yeah, looking forward to it.
And what I would say in closing is, it's an exciting time for practitioners in Europe because you have, although these are all nascent regimes and everything is it's just amazing to see how things are developing and new class action statutes are coming to the fore. I would just counsel everybody that be mindful of what it is what suits you bring, how you bring them, and what precedents you set. Because if you make bad law, it will impact the regime going forward for a long, long time. So sometimes it's important to recognize this is not a case we should be bringing because of what damage it could do to the regime going forward. And it's just, we've seen that in the United States where people have decided to take appeals where they shouldn't have taken appeals, and bad decisions are rendered by the Supreme Court or the Court of Appeals, and it redounds to everybody's detriment within the bar. So that would be my only 2 cents to add.
Don't make bad law seems like a good one to wrap up on.
Yeah.
Do we have any questions for the panel before we finish? No. All right, well, I want to thank my panelists for their very insightful commentary.
Thank you very much.
Thank you.
Thanks, Loree.